Well, welcome back to Chapter 4, Agency Issues. Let's review the highlights of this chapter, the more critical things that you want to know as you prepare for the final examination. I'll also try to tell you some of the things that aren't really necessary for you to really spend too much time with as we go through this as well. First thing we find on page 63 is agency defined. A relationship in which a real estate broker or licensee, whether directly or through an affiliated licensee, represents a consumer by the consumer's consent, whether expressed or implied, in a real property transaction. Wow, pretty good definition. By the time we're through with this chapter, you can come back to that. It'll probably make a little more sense. So let's go ahead and get into the chapter then. First is our agency is laid out very specifically in the Real Estate License Act of 2000. Therefore, our agency law in Illinois, would sometimes be referred to as our designated agency law, is a statutory agency law, which means that it was created by our General Assembly and signed in to effect by our governor back in the year 2000. So all we need to have is the Illinois License Act 2000, a copy of that, and we'll know all the things we need to know about designated agency. We're going to cover a lot of that in this chapter that's in the License Act. First of all, to kind of set the stage, we have consumer, client, and customer. Sometimes this is confusing to students. Let's try to make some sense of it. A consumer is someone who is standing outside your office looking through the window of your real estate office. As they stand out there in the street, they're a consumer. When they walk in that office and you start to work with them, they're either going to have to be made a client or they're going to have to be made a customer. If they're a consumer standing outside looking in, inquiring about duties and just talking to you about the real estate business and what you do and what your services are and how you do your services, okay, you owe them no duties. But when you start working with them, they're either going to become a customer or a client. If you make them a customer, then you're going to owe them Ministerial Acts, found on page 73. If you make them a client, or they want you to make them a client, then you owe them duties called fiduciary duties, found on page 63. Sometimes fiduciary duties are also called agency duties. If you want to, you can call them client-level duties. But the important thing is, if you look at our pyramid, from consumer to client, can we see that the agent owes more and more duties as we go, up the pyramid or down the pyramid, so to speak. The consumer, then, is someone interested in our services. No duties are obligated by either party. The client is the principal the agent works for, while a customer is the individual the agent works with. Even though we do not owe customers fiduciary duties, we do owe them these duties. We owe them customer duties of factual information, honest and fair dealing, material disclosures, and of course this thing called Ministerial Acts. But a customer never receives advice or counsel or any confidential information about any client without specific consent from the client. Types of agency relationships. There are universal agents, general agents, special agents, designated agents, and what are called disclosed dual agents. A universal agent, which we do not have in the real estate business, where you can do a variety of many different types of duties and activities, and that universal agent has very, very broad powers, and probably even include the broad powers to engage their clients in contracts. General agents we do have in the real estate business. This is where they have many duties involved around one activity. For instance, property managers might have the duty to maintain the property in good repair, negotiate with tenants, hold security deposits, make repairs on the property, contract with for the property manager's building for services to the building, and perhaps even do some accounting as far as their revenue and their expenses, so that at the end of the month the landlord, property owner, can see kind of what his NOI or net operating income is. That may be part of his duties too. Okay, so many only one activity but many duties around it. Special agents are agents that do one specific activity for one specific act, and when that specific act is over, their duties are done. And that would be the typical real estate agent. We do one activity. We list a property, for instance. And when that property is sold, then our duty under contract has been terminated. The contract is done. We're representing a buyer. As soon as the buyer buys, contract is over. Our special agency is then terminated. A designated agent is anyone who is authorized by one to act for another. Typically, a designated agent means we have someone like your sponsoring broker or your managing broker might authorize you then to be the agent for a seller, or perhaps your sponsoring or managing broker might authorize you to act as a fiduciary to a buyer, in which case the buyer becomes your client. Disclosed dual agent. You might be a dual agent where you act for both parties. You represent both parties. Both parties, both seller and buyer, are your client. Kind of a dangerous situation, so you have to be careful of with dual agency. Designated agency is a contractual relationship between the broker or one or more people associated with that broker then can represent that client as their designated agent. Page 66 talks a little bit more about this, and we'll get to that too. Licensees are presumed to represent the consumer they're working for as a designated agent unless there's a written agreement between the sponsoring broker and the consumer, or the licensee is performing only ministerial acts on behalf of the consumer. So essentially what we're saying is that, as we said before, the consumer walks in, no duties are offered. When you walk out with that consumer, let's just say it's a buyer, then you're either going to have to you are automatically going to be representing that buyer as their agent unless you have a written agreement saying, no, buyer, I'm not going to be your agent. I'm going to assist you, and you'll be my customer. And what I'll be able to do for you is offer you ministerial acts. So you have to make them either a client or a customer. Typically with sellers, they're usually always your client when you have a brokerage agreement like a listing agreement with the seller. 99% of the time, you're going to be representing the seller. Designated agency on page 65 gets in a little more specifically into what you can and can't do as a designated agent. The big thing about the designated agency is it says in our brokerage agreements, therefore, we will have a little place in there. There'll be a paragraph in there where it allows the sponsoring or managing broker to designate someone in his office then as the agent of the seller, the buyer, the landlord, the tenant, an exchanger, or an exchangee. On page 66, as we talk about accepted designated agent activities, agency disclosures are required when there are contemporaneous offers. This is where you're representing two buyers, you're showing them the same property. You can do that. Now, page 113, and we'll get to that later, is a good form that you can use, because if you're representing two buyers and you're going to show them the same property, you need to give them written notification that you're going to do that. And that form on page 113 is a good form to use, or something like it is a good form to use. You can get many of these forms through the IAR, and if you can't get them through the IAR for some reason, they're not a member or they're not going to sell them to you for some reason, then certainly have your legal counsel draft them up for you. Dual agency, again, some good forms that the IAR has put out. Forms on page 70, figure 4.3, and page 72, figure 4.4 are good forms that you can use for dual agency and dual agency disclosure and confirmation of dual agency. So the critical deal with dual agency is you can be a dual agent. It's legal, but you must provide written notice and get written consent before you act as an agent as a dual agent. Written notice and written consent by all parties before you can act as a dual agent. And again, those forms are good forms you can use to give that kind of notice and get that consent. Page 71 spells out exactly what you can and cannot do as a dual agent. So something at some point in time in your career, if you haven't done so already, And if you ever become a dual agent, you might want to keep page 71 handy to take a look at. Just refresh your memory about what your duties are as a dual agent to these two clients. Customer duties, as we said before, you still have duties to customers. They're not fiduciary or client level duties, but they're still important duties. Treat all customers honestly and ethically. Disclose any latent, hidden material adverse effects relating to the physical condition of the property. Disclose to any unrepresented customer in writing that you will not be representing them as their agent, but as a customer. And we do not owe client-level fiduciary duties to customers. Ministerial acts do not rise to agency duties. So ministerial acts are these acts that we can do for customers and not have our relationship rise to an agency level relationship. The licensee may perform ministerial acts for a customer without violating any brokerage agreement with the client, and performing those ministerial acts for the customer will not be construed in a manner that forms a brokerage agreement with the customer. Ministerial acts are informative or clerical in nature, and page 75 does a good job of laying all these ministerial acts out. And again, at some point in time in your career, hopefully you'll spend a little time and just read them through one time. It's good information that you really should have as a professional, ethical, and competent real estate licensee in Illinois. Minimum services, we have in our Real Estate License Act a section on minimum services, which basically say when you take a listing agreement, when you're working with buyers, you offer them minimum services. This is really designed for what I will call flat fee brokers. Flat fee brokers would charge a seller a flat fee, a nominal flat fee, to, quote, list their property. The whole idea being, I'll put it in a multiple listing service for you, but because I'm not charging you very much, you're on your own. So in Illinois, we said that's not very professional conduct. Consumers aren't getting the best protection if individuals are offering less than minimum services, just putting a property in the MLS. So part of our license law says when you take a listing, you have to do these things as a minimum service to your client seller. You have to accept delivery of and present to the client offers and counteroffers. You have to assist the client in developing, communicating, negotiating, and presenting offers, counteroffers, and any notices between the parties. And you have to answer any of your client's questions. This, however, does not pertain to what we call open listings. Minimum services apply to when you list property as an exclusive agency or an exclusive right to sell listing. That's sort of where you're only representing one seller and one agent is representing one seller, even though in one of those listings the seller can still sell himself, which is the exclusive agency. Open listing is a listing where a seller says, hey, all you brokers out there, the first one to sell my property is the one I'll pay you a commission. That's called an open listing. You don't have to provide any minimum services in such sort of a loose listing arrangement as an open listing provides. I might also say that open listings are typically not eligible to be entered into multiple listing services. Only exclusive agency and exclusive right to sell listings, what are called exclusive listings, can be put in the MLS. Open listings cannot. Duties after termination of agency. Sorry for misspelling. Duties after termination of agency. Account for all monies, even after when the agency is over, property sold, maybe the listing contract's expired, maybe it's been terminated or pulled off the market. For some reason, the listing is now over. You still owe the duties of accounting for all monies in a transaction, and you still owe the duty of confidentiality for information that you receive from your clients. You can disclose confidential information if it becomes public or if you have written permission to disclose, but be careful with confidential information. Okay, take your Chapter 4 Agency Issues Review quiz. Good luck.